Mikaël Hervé. Welcome to Digital Markets Research Hub. You've been talking about AdTech well before it became mainstream, looking at the earliest cases, contributing to having stakes in the earliest cases, and explaining to broader competition law, economics, and policy community the technicalities of AdTech. So given the prominence and the importance and further development in this pivotal area of digital economy, and given your deep understanding of it and also easygoingness with which you explain these issues, I decided to begin this conversation with inviting you to highlight to us the basic elements and maybe explain why it is such an important area of the economy.
Thank you, Aless. Well, first, it's a great pleasure to be here and take part in your channel alongside so many amazing experts, academics, and enforcers. Before I kick off, a quick word of disclosure, because I think it's important. So I've been advising, indeed for many years now, clients in the digital sector, including on cases adverse to Google, such as search, AdTech, shopping, maps, automotive, and news. And I've been doing work for Amazon on several issues, including cloud and retail. So yeah, I'll start with a brief overview and then say why all this matters. So let me start with a brief overview of the advertising space. There are two broad types of advertising: search advertising and display advertising. Search advertising are ads on Google search, Bing, that appear typically in response to a search query. So you search for running shoes, you might get an ad for Adidas trainers on the results page. Display advertising, on the other hand, are ads that are displayed on a website or a mobile app, typically next to some other content. So you might also get an Adidas ad while you're reading an article on the New York Times or The Economist about something completely unrelated, like Trump's formula to calculate tariffs. Let me already say that the two historical US judgments of this year and late last year found that Google acted legally to maintain a monopoly position in markets in both of these sectors. So these are the search and AdTech judgments, essentially covering the two main types of online advertising. These judgments, I think, will be hugely consequential in the US, but I think also in Europe for what's coming next. So you asked about AdTech specifically. What is it? AdTech is about open display advertising. What do we mean by that? We mean advertising on any website on the open web. So it's literally all ads, apart from those shown on large owned and operated platforms such as Facebook, Instagram, and TikTok. It's everything else. And what is commonly referred to as the AdTech stack consists of various intermediaries that facilitate in real time the sale of online advertising space between sellers, which we call publishers, like the New York Times, and buyers, which are advertisers like Adidas. So you have some tools that are used by advertisers on the buy side and other tools that are used by publishers on the sell side. And in between, there are exchanges where the buy side and the sell side connect. So in other words, AdTech intermediaries help connect advertisers on the one hand and publishers on the other hand that have ad space to sell. So you might wonder, why do they exist? Why can't you have, say, Adidas go directly to the New York Times and buy ads directly? Well, these direct sales are actually possible, and it is how it was done historically. However, it might be quite inefficient for at least three reasons. The first is that there would be significant transaction costs if all publishers and advertisers have to negotiate individually. Second, if you're a publisher like the New York Times, you don't even know how many ads you will have to sell, right? That's because the number of ads that will be ad slots that will be generated depends on the amount of traffic that you get on your website, which you cannot precisely anticipate. So that's why it's more efficient to do it in real time with some kind of automated process. Third, you do not know in advance the profile of your readers either, right? For example, is it someone that is potentially interested in running? If the person has no interest in sports whatsoever, then it's probably not a good idea to display ads for sports equipment. So long story short, if you're a publisher, you need these AdTech intermediaries so that you can instantly connect to multiple advertisers at the same time. And the same goes for advertisers. By using these tools, they gain access to thousands of websites at once. So now, let me say a word on why it matters. We've essentially witnessed a change of paradigm in advertising, moving away from contextual advertising towards programmatic advertising. So contextual advertising is, for example, and I'm going to keep the same example to fix ideas, if you have an ad for Adidas trainers in a running magazine, right? So there, it's the publisher's content that is the basis for targeting. Now, with AdTech programmatic advertising, you can have the same ad displayed while you're reading an article about something completely unrelated, about, say, quantum physics, simply because the advertiser knows that you like running, as well as pondering about the existence of dark matter. So the economic implication of this is quite important. It means that the value is no longer with those creating content, it is with those who have access to data and targeting capabilities. And that is Google and Meta, essentially. So while Google and Meta revenues have skyrocketed, newspapers have been facing, as we know, severe financial difficulties. And that is a concern, of course, when we are all aware of the importance of having access to quality journalism to our democratic societies. And it's not just about press content. We are essentially talking about the entire open web. As a whole, the digital advertising infrastructure that I've been describing has become critical for vast swathes of the economy, from publishers to advertisers to consumers. Daron Acemoglu, last year's Nobel Prize laureate in economics, has reminded us of this in a recent essay, asking for Europe to follow the US example and rule against Google's monopoly in AdTech. So that's why, in essence, AdTech has received so much attention from regulators around the world, and why it matters so much that we have effective competition in these markets. How does it work in practice? Well, when you open a website, any website, right, while the content loads on the page, you have a near instantaneous series of auctions and transactions that takes place to determine which ads will be shown to you on the page. And this process involves sending requests for bids, and in response, advertiser bids sent through a chain of various intermediaries to match the space on the web page with the advertiser willing to pay the most for it. And the role of AdTech intermediaries in this context is to facilitate this, facilitate the placements of ads and organize auctions in real time to determine the price at which the ad space will sell. And they charge a commission or a take rate along the way. So these intermediaries talk to each other, and they are put in competition to find, sort of, imagine that it has to be the best match, right? And all this happens in milliseconds while you load the page. From an economic perspective, I mentioned best match. What do we mean by that? Well, the best match, or the best allocation, is the one where the ad goes to the buyer that has the highest willingness to pay. It is fair and generally benefits all players. It benefits advertisers because their surplus can be maximized. It benefits publishers because they can get the best price. And it benefits intermediaries that are the most competitive and provide this best match. According to regulators, Google's conduct has precisely prevented this from happening. And then the consequence would be that, well, if this benefits all sides, then the consequence is that potentially this conduct has harmed all stakeholders, so advertisers, publishers, and rivals.
A clarificatory question, if I may.
Sure.
So we have two, you started with explaining that there are two different but interrelated markets, search and display advertising. both are being driven by programmatic as well as contextual, but both are being driven by programmatic advertising, if I understand correctly. So Google search also auctions its search on the top.
Yes, that is right. That is right. So typically the distinction, so I mean, two things. First, so search advertising and display advertising are typically considered separate markets, right? I mean, that's just from a sort of antitrust perspective. And there are many good reasons for this. They don't serve the same purpose. Essentially, one of the key reasons is that the intent is much higher on search, because if you look for running shoes, clearly you're interested in running shoes, right? Whereas display advertising is more about brand awareness. So you're not necessarily looking for, shoes, as I was describing. You're reading an article about dark matter, but maybe why not? You need new running shoes as well. So typically these are more complementary in a way. So that's the first thing. Then in terms of the technology that is used, you're right that there are some similarities in the sense that Google is also organizing auctions. But the key difference there is that Google is not using third-party intermediaries. So it's Google that is kind of vertically integrated and that organizes everything directly. So that's a key distinction. And it is also a distinction that you can find in display advertising, because some of the largest players, say Meta, will also be, we talk about owned and operated display advertising instead of open display advertising. The difference is that Meta has access to the entire vertical, the entire stack, and will do it itself, essentially. It has the technology. It doesn't use third parties to sell its own ad space, its own ad inventory. But that's not possible to do for smaller publishers, obviously, because you need scale and you need the technical capability, so it wouldn't make sense. So that's why you have these ad tech intermediaries that help within open display advertising, the sale of advertising.
And while the dominance of Google in search is self-evident, when we talk about display, its market share is much lower, and yet it's sufficient enough to be considered dominant because maybe they synchronize their data with search.
So I think what is really important is that in open display advertising, there are two sides, obviously. So you have the publisher side and the advertiser side. And the thing is, so there are several relevant markets. So a relevant market for the ad server, which is used by publishers, right? So imagine you're a publisher, you need an ad server, and the ad server is sort of managing in real time your ad inventory that is created on the page as you get traffic. Well, if you're a publisher, you need an ad server. Okay, what are your options? There are a couple of, I mean, it's essentially Google, but leaving that aside, then the question is, okay, but you also have Facebook. But the thing is, Facebook is not an option because the ad server of Facebook is just for Facebook. So essentially, you can forget about owned and operated display advertising in this instance, because from the publisher's perspective, Facebook is not an option. Now, what you're describing is something a bit different, is to think, oh, on the advertiser side, is Facebook, so essentially is placing an ad on Facebook, an alternative to placing an ad on some other website, which is kind of a separate, it doesn't change anything on relevant market, further down from the publisher's perspective. And this has been typically an open question on as to whether there is some kind of substitutability between the two types of advertising. And also, because I just described it as if it was only two markets, but there are many layers in between. So now if I think about an ad exchange, well, an ad exchange, which is in the middle, needs to have access to what? You're an exchange, by definition, you need to have access to two things. You need to have access to demand and supply, right? So you need to have access to the inventory of publishers. So that's why you connect to ad servers that are used by publishers. And you need to have access to advertiser demand, which is what's called like DSPs, so demand side platforms, and which are at a different layer, right? So you have these three layers and you're in between. Well, from an ad exchange perspective, again, Meta is not really an alternative because you're active within open display, so you need to have access to, well, the inventory, the open display inventory, that is publishers. So you need to connect to ad servers, and you also need to connect to DSPs to get some demand, and some major DSPs are owned by Google, so Google Ads, DV360. And the conduct is essentially sort of depriving, I mean, according to decisions, not just or even the press release of the commission, depriving these ad exchanges in the middle from both of these things, right? So both demand and supply. And I think perhaps it's maybe just to fix ideas, I have one slide that I will show you because I think it helps just to get some kind of visual to fix IDs, which is from the commission's press release. So hopefully you can see that. That's what I've been describing, right? So the three layers: publishers on the one hand, advertisers on the other hand, and then three layers within the stack. What I was saying is, if you're a publisher, let's start there. Okay, you connect to DFP. And DFP is the ad server of Google, and there aren't many alternatives. Meta is not an option. This is connecting to the ad exchange in the middle. AdX is owned by Google and is also very prominent. And third, on the buy side, you have some DSPs to which advertisers connect. And you can see that the conduct, according to the preliminary findings of the commission, is that you have some kind of self-preferencing on both ends, right? You have this kind of pincer movement or the opposite of a pincer movement, but like both are favoring, both the ad server on the sell side and the DSPs on the buy side are favoring the exchange of Google AdX in the middle.
Right. Let us now move from this really detailed and nuanced and yet clear and approachable explanation of the mechanics of online advertising to the regulatory area. Maybe we can identify the moment when it became so entrenched, or maybe not necessarily a moment, but I imagine there was big gap between the enforcement understanding or regulators understanding of the importance of digital advertising or digital economy in general and the development of the market of the industry. So we lost the moment. Now we try to somehow to decrease this gap and to catch up. What are the landmark maybe decisions or maybe even regulatory attempts to bring some order and to maybe to protect, if not enhance competition in these markets? Yeah.
So that's a good question. So first you mentioned when the market has tipped, and I'll just say a quick word on that. It's difficult to pinpoint when the industry has tipped. I mean, according to decisions so far, it's at least from 2014, according to the French decision and according to the EC preliminary findings. And the US judgment talks about over a decade of illegal behavior, but it might go back even further to around 2008, I think, when DoubleClick was acquired by Google, and Google became dominant quickly after. But the point is, this happened at the same time as the market was created, in a sense, at the same time as programmatic advertising became a thing. So the notion of tipping is not necessarily relevant, I think, in this market. However, the key question is, when can we say that the conduct, when did the conduct start become anti-competitive, arguably? And I think that's an interesting question, because the sort of same conduct, there are nuances, but the same conduct can be seen as an efficiency initially, but then become anti-competitive later on. So let me give you an example with dynamic allocation, what is called dynamic allocation. And I'll keep it brief, but dynamic allocation is a technology that DoubleClick invented, not Google, DoubleClick, which allowed buyers to submit bids in real time. So this is efficient because it's better to get bids in real time, accounting for the specific characteristics of, say, the user of the ad in real time. So, for example, if there is some interest in buying running shoes. However, it becomes arguably anti-competitive if Google then forces that the technology is only available to Google when the technology has actually matured and is technically feasible for everyone to do the same. Then I think these artificial restrictions can become more problematic, because the counterfactual is not that, oh, you do not get the innovation, is that you get the innovation widespread to the entire market. And that's kind of, you find this kind of reasoning in the US judgment, and even on DoubleClick. I mentioned DoubleClick, that may be why the judge considered that the acquisition of DoubleClick in itself was not illegal, right? Because Google might have improved the service initially. The reason why I wanted to mention this is that this could be relevant to other cases, and potentially in the context of the DMA. When you think about the interplay between innovation and self-referencing, when you innovate, it could make sense that initially you do it on your platform, because within your ecosystem, because the technology can interpret, it works best. But it becomes more concerning when the technology has been there for a while and customers demand interoperability and it's technically feasible, but a dominant company finds ways of artificially restricting access. And especially in this industry where the value is in the connection, not in the individual products themselves. And you have quotes from Google internal documents saying this exact thing. It's in the US judgment, like it's page 97. I think this one in particular is quite interesting. So, but this requires dominance, and that's why we like competition so much, right? Because when you have competition and you have something that is possible, technically possible, and beneficial to consumers, typically it does occur. But when you're dominant, potentially can restrict access. So to your second point about, okay, what are the sort of the milestones of regulatory development? I think that, so the interest started many years ago. I think that the CMA opened its market study in 2019. So I would say already that, yeah, there has been a lot of interest. It took a lot of time, maybe for good reasons, because yeah, well, you need time to build the knowledge. However, when you look at the market study, I think a lot of the issues that you find in the more recent judgments were there already in the market study of the CMA. So there is a bit of a question mark about whether we could be, act faster when the issues have been identified. They have not really changed, I think, for many years. So clearly it was not very quick. But what are then concretely the decisions? So first decision was released in 2021 by the French competition authority. So they were the first. What is noteworthy about this decision is that it's final. Google settled, right? So there is no appeal possible because Google decided not to contest the decision. And Google also took a series of behavioral commitments, behavioral remedies or commitments. It was like Google deciding the commitments, but so at the time to be applied globally, not just in France. Okay, the second important development has been, well, a couple of weeks ago, the US judgment by Judge Brinkma, finding that Google acted illegally for over a decade. And in terms of scope, it's actually very similar to the French decision. The main difference lies in the remedies. As you know, the US court is seeking structural remedies instead of behavioral, indicating in passing, by the way, that they were probably not very impressed by the behavioral commitments that Google took following the French decision. Third is the statement of objection sent by the European Commission. And potentially we could have seen a decision by now, but in the current economic context, it could have made sense for the Commission to wait for the US to shoot first. So now that the US judgment is out, we may expect a decision by the European Commission soon, and probably this year. The European Commission is also seeking structural remedies or considering structural remedies according to its press release. The main difference between the European Commission's approach and the US judgment is that, according to the preliminary findings, the European Commission seems to look at broader issues. In particular, remember the sell side and the buy side I was displaying on screen before. The European Commission is looking into the sell side in some more, in the buy side in some more detail. And the last one I wanted to mention is the UK CMA. So as I said, they were the first, but might be the last in the end. What happened with the CMA, I think is quite interesting. So there was the market study, which, by the way, is, I think, a very good resource. It's like a 2,000-page opus in total, if you include annexes on digital advertising. So there is a lot of information in there. But after, there was a question, okay, would it lead to a market investigation? Because as you know, they can then impose remedies following a market investigation. The decision was, let's not do this. Let's do regulation with the DMU instead, or, passing the baton to the DMU. But then it took time to happen. So anyway, they decided in the end to do a classic antitrust case, kind of, and send a statement of objection. But I don't think we'll see a decision before 2026 on the UK side. And there are others in Australia and Canada, so, well, essentially, by now you'll have understood that virtually all major regulators are investigating AdTech, and so far, all regulators have found problems warranting intervention.
And within these cases, which you have highlighted, two are considered by the community as kind of most impactful, or at least having the potential of triggering some significant changes to probably the entire industry, or maybe a significant part of it. Both US AdTech case and search case. Can you highlight the key elements, or I mean, why these cases are so important? You have highlighted the technological side, but maybe in addition to what you have explained to us in terms of the mechanics, also explain the relevance of these cases and the main findings.
Yeah, so the main, just because I think we talked in abstract about what sort of Google did, maybe it's worth just giving a bit of the intuition of what happened. And so, essentially Google is active across every layer of the stack, and that creates conflicts of interest, because rather than connecting to third parties, it can favor itself. And there is often a parallel that is made with financial markets, and even Google likens its ad exchange to the New York Stock Exchange of advertising in its internal documents. So there are differences, but of course one is that it's not regulated and quite opaque, with the same player organizing and participating in its own auctions, right, at the same time. So you can easily conceive how conflicts of interest are likely to arise. And if you have market power, then you can exploit essentially this conflict of interest to your advantage. This sort of encapsulates the essence of the AdTech case, and in terms of findings. If I were to give two specific examples, one is first look and the other one is last look. First look simply means that Google could participate in auctions before everyone else. So clear advantage to Google, that can win the most premium inventory and before all others. That has an impact on rivals, but publishers as well. I think it's quite easy to see that. The question remains: can you have an objective justification for the conduct? And that was looked at by regulators in the US judgment in particular, and in the French decision before. Then last look is the opposite now. Instead of participating before, Google could participate after, knowing the price to beat. So could outbid by just 1 penny, because if you bid after everyone else and the bids of everyone, then it's easy to win by just outbidding by 1 cent. And then the question was, okay, but what is the counterfactual? If you remove this, Google would have won or lost the ad space. What's the counterfactual? And I think these were interesting questions about the impact ultimately, and whether who was harmed along the way, especially when you have these multi-sided markets. And if it harms one side, could it be justified because it benefits the other? So typically that was the kind of, I think, interesting economically questions of this. So he said, well, the industry thinks that the US might have the bigger impact. I think, so far we don't have any. So we have the French decision with some behavioral commitments, which according to the industry had no impact. As I said, the US judgment sort of implicitly or explicitly considers that, well, there is still a problem, that behavioral remedies didn't make a difference. So the fact that now we are talking about structural remedies is probably the reason why the industry thinks that it could have a bigger impact. That's the first thing. Second, is the fact that it will influence what happens in Europe, and potentially, Europe and US approaches will be complementary. And maybe what's going to work to inject more competition is a sort of combination of both approaches. Let's see what the Commission, I think we'll have to wait and see for the European Commission's decision, but probably the view was, well, behavioral remedies have not been working in this case. And then you might wonder, we have the DMA. Could the DMA help? There is not much regarding AdTech in the DMA in Europe. It's essentially about disclosing data, which is super important. I think it's going to be complementary. So data on the fees, for example, that AdTech intermediaries or Google were taking along the way. As I said, they charge commissions. And this is quite opaque. It's very difficult to know how much of the advertising spend Google takes in the middle. So I think that this will contribute, because you can't have competitive reactions to a price increase or a quality decrease if you don't know about it. So I think this provision in the DMA is actually complementary, but I don't think it's going to be sufficient, and clearly regulators do not think so either. Now on search, so search is of course another major. As I said at the beginning, when you think about AdTech and search, you're covering the two main types, kind of the full spectrum of advertising, especially if you leave aside the like Meta, TikTok, and this aside. So search is also extremely important on the economics. I would say that the economics make sense. The sort of the theory of harm is essentially a story of scale. So you have this ability to foreclose. The ability to foreclose is by depriving rivals of scale, by controlling essentially all search access points, whether Android devices, Apple devices, or desktop devices, and that has the ability to foreclose rivals because you need scale to compete. Relatedly, because that was, I think, a very interesting question, is default status. What is the role of default status? Well, I think that now we have seen a lot of evidence that default status matters. I do believe that we are past the narrative that competition is a click away. There is tons of evidence that users, from behavioral economics, that users tend to stick to the default, and there can be many reasons why. We observe such behaviors. At our last CRA conference, we invited Professor Antonio Rangel, and I think it was really good to have. He testified in this case, in the search case, and he's a behavioral economist, and it was really insightful, at least to me, to listen to what he had to say. So now, I was talking about like ability on incentives. I think incentives are there simply because when you look at the internal documents, even you see that Google is talking about an incredibly lucrative, one of the most profitable business ever. So incentives to maintain some kind of market power is of course there. The $20 billion payment to Apple, in particular, was raising many questions, many interesting questions. How can you justify this payment? Was essentially the point. Is it paying for distribution? Is it anti-competitive motivated? And I think one way of understanding the economic intuition as to why it can be both profitable to Google and effective at excluding rivals is that the profit of a monopoly is higher than the market-wide total profit of a duopoly. That's a sort of basic intuition. Now, like for any competition case, it's super important to consider counter-arguments and whether the conduct can have either a more benign explanation or whether it can be objectively justified. So the US judge was not convinced by the arguments brought up by Google. And just to finish, I mean, on more the economics, but one interesting feature I think or question is the potential impact of diminishing returns, right? Because if there are diminishing returns to scale, it means that a rival search engine, a smaller rival search engine, would gain a lot by getting more traffic, just because it gains scale, initially, and you need that to compete. So some additional queries can make the difference. They can move the dial on your competitiveness. Now, if you're a larger player, if you have scaled already, getting some more traffic data, getting some more traffic may not move the dial as much. However, if you know that by getting this traffic, you prevent someone else from having it and become more competitive, then you might still want to take it. So this is a sort of coherent economic thinking about what may have happened, and there are economic papers sort of showing this, that essentially default payments, what I'm saying is in a nutshell, is default payments may be pro-competitive if done by smaller search engines that want to increase quality by increasing their scale, but anti-competitive when made by a dominant company that is more motivated by sort of cementing its market power. Now, because you asked what is the implication in industry, and is it what will be the consequences? Many questions. Then it's not the end at all. I think of these cases, Google will appeal. So I think we'll have to. It's clearly not a done deal. And then the next question, once you have some kind of judgment like this, is what do we do? What are the remedies? And I think we know by now that remedies maybe are even more difficult than just finding an abuse. So what is considered is divesting Chrome, and yes, I mean it's difficult. I think it's a bit of a question why I don't have very strong views divesting Chrome. I think the initial reaction is the case was about search, not about browsers. So of course I can see how Chrome will contribute, but it raises many questions as to the impact of a divestment of Chrome will have ultimately on the market. The remedies that are considered in AdTech, I think in AdTech it may be easier to solve, to create more competition if just you break the chain between like the AdTech, if you break the sort of conflict of interest that I was describing before. And I'll just very briefly, and then I'm done, but just for you to have this visual as well. That's an example of what, well, the US and the European Commission are considering, just breaking, that's from the EC press release, but just some kind of divestment to break the conflict of interest and separate the buy side and the sell side.
Excellent. You mentioned, by the way, CRA conference. It's a great venue. We do it annually, and it's accessible online. So thank you very much for reminding about this event. Annual. Speaking of on the remedies, or rather, we all agree, or the vast majority agrees on the state of affair is not ideal, far from ideal. But when we talk about what do we want, people have their own interests, and I imagine the US and the EU interest might differ in some respect, and also normatively, ideologically, many would say it's not our job. Let the market to define. Our task is just to interrupt this this bubble from becoming comprehensive, and then the invisible hand will sort the things out. Others say that we need to engage in some kind of regulatory micromanagement, trying to at least to set up what would be an optimal or desirable structure of digital markets. We have huge industry in the past, and now it was super huge, now it was just huge. Publishers, they've been probably, according to some, losing the momentum on the eve of online advertising era, because they control the markets, and now it evolved, and now they are somehow in a more dependent position. So do we have to support them, maybe to expect from them to develop what? To develop an alternative, or just having more opportunities in the existing infrastructure? How do you visualize for yourself and for us the kind of the end goal? There is no end goal, but somehow something which can be projected as an end goal.
Yeah, I mean, it's not an easy one. I do believe that we can sort of help a lot the market by setting a sort of a structure, and rather than just intervening directly and just deciding what we have to do, that we should, I mean, first, essentially, as I was describing before, enforcing competition laws or enforcing the new regulation that we have. That would be the first step. It could have helped a lot. I believe that if as I said, from 2019 already, we had identified issues. So if you can act and do something about it more quickly, perhaps you don't end up in this situation. You mentioned publishers in particular, or and newspapers. I think that the counterfactual could have been completely different without the conduct, because when you think about it, we're talking about open display. It's not a foregone conclusion that you would have Google dominate the space, because as you say, they have their inventory. Advertisers want to buy this inventory. It's quite valuable on many newspapers, but you just need some kind of scale, so you need tools. And I think there it was this sort of in my view at least, and it's shared by many regulators now, but it is the anti-competitive tactics that led to this outcome. So there is an alternative that is possible. I doubt that it would come from publishers themselves, and I don't think that it would necessarily make sense to ask them to create this stack for the reasons I mentioned, because there are some large publishers, but it's quite fragmented. So I don't think they would have the resources, and that's why we have competition, because there is some value, and with competition, essentially, the tools will exactly do what publishers were seeking, which is not, it's not beyond the will of man. We're just saying there are many buyers, we want to put them in competition. It's as simple as that. In real time, all of them, and they all do it because they are all disciplined by competition, but Google, and that's factual, right? I think what is interesting is the behavior I was describing is unique to Google. Just the fact that Google will not participating in auctions organized by others, or the fact that on auctions it organizes, it will favor itself. That is very unique. So that's what they need, and then it would have, in a sense, sufficed. The change of paradigm I was describing, you might think, okay, but you still need targeting and data capabilities and all that, but that is possible to get outside, Google and Meta to some extent. And Google as a buyer could participate with its own data and everything. It would be great, right? But just participating in a head-to-head auction and see what happens instead. So when you look at internal documents, just to add something there, is on the buy side, because we talked a lot about on the sell side, but it was in the US judgment, according to US judgment on internal documents. The buy side tools, people internally at Google wanted the buy side to participate in auctions of everyone. But because they had other interests on the other side, and they knew that by tying everything, then it would sort of create more market power, they said no to the business, don't do it. Even if it would harm advertisers. So I think if you break the chain, the incentives are completely changed, and it would have a massive implication potentially on the industry.
Great. The last question on AdTech. What is the role of privacy and sandbox saga in this overall constellation, and it's kind of the end of the initiative? Is it a incremental contribution to a healthier competition, or as some privacy advocates plead, it will somehow allow more oxygen to third-party cookies, brokers, who often interfere too much and learned so much? How do you see the latest development with Privacy Sandbox?
Yeah, I think Privacy Sandbox, so before it was, I mean, there was a lot of questions, especially when the remedies were considered. Could Privacy Sandbox play a prominent role? You know, if Google is forced to divest something, could it replicate this somewhere else? So basically, the role of Privacy Sandbox was debated a lot. Well, you know, the end of that. I mean, there were many concerns about what Google could do. The CMA, as you know, sort of played a major role, I think, in making sure that or addressing some concerns. I think, I mean, to me now, with the structural remedies that are being considered, it will be first, is it viable? Is anyone willing to buy these technologies? Instead, and second, do you need something else to say, well, you can't recreate the same thing somehow, say via, so of course if Chrome is divested it won't be possible, but at some point there was a question, you know, Privacy Sandbox was within Chrome, the browser was taking a lot of importance anyway, but the browser is the first sort of layer on the user side. So if you have this dominant, you know, the way to think about this industry, and then which has implications for like Privacy Sandbox and all that, is whether you have market power on the user side. Potentially, the first one is Chrome. On the other side, it will be access to advertisers. Of course, if you're Google, you have access to advertisers because at least they want to use Google search, and then you have the connections and you can use that. And what happened was to sort of really by a series of ties, that's the theory of harm, right? Just reinforce the other side and vice versa. That was the story. So if the source is on the advertiser side in particular, you have to think about you know, future-proof remedies, including some evolution of the advertising industry. And yeah, privacy more generally, as we know, there are many interactions between competition and privacy. And privacy, I believe that, you know, should be the first thing to enforce. And then within these conditions, then you can maximize. It makes sense to maximize the revenues that publishers can get. And keep in mind, if you have this healthy competition auction, it benefits both sides. And that's quite important because I often get the question, oh, but then publishers would have got more money. It means advertisers would have got less. Well, not necessarily, right? It doesn't follow if actually the impact would be that the middleman keeps a higher cut of the spend.
I know, Mikaël, that you've been also working hard on one of the latest cases, Google Maps Automotive in Germany. Can you please explain to us the key elements of the case?
Yeah, I can do that briefly. I think that it is. I mean, what I find interesting about the case is, and I'll tell you what it is in more detail after, but it's a sort of it's a good example of competition regulation. You're talking about, you know, that's very topical, and in a way it's complementary to the DMA because that's not something that was really tackled or within the DMA. So what is the case about? There are two subcases. One is about Android, like Google Automotive Services. So I think the best way to think about it at a high level is think of the Android case in before the European Commission and apply this to cars. So what do I mean by that? It's connected cars. More and more, cars are that integrate directly in the car. I'm not talking about, forget about your smartphone or there is like CarPlay, you can do some kind of screen sharing. That's not what it is about. It's directly integrated. So the car itself has an operating system. And you have Android, very active. So Google has Android Automotive Operating System, AAOS. So it's sort of replica of what you've seen in smartphones. Android becoming the dominant operating system because it has access to developers and everything. So you create an ecosystem. And then the concern, and I mean, the reason why the German authority intervened is that Google was then tying all its applications within GAS, Google Automotive Services, so that you couldn't get access to one of them individually. So that is Google Maps, the Google Play Store. That's why I'm saying it's same as Android in a way, or it shares many similarities, and the voice assistant. And what was the potential motivation of that is, again, about search access points. That is the entire business model of Google. So it makes sense that you would want to sort of control the search access points. What are the search access points in a car? It's Google Maps, you search for places, or the voice assistant maybe itself, because you will ask directly to the voice assistant. So anyway, everything was tied together. It was not possible to take the operating system with the Play Store so that you have a properly functioning operating system, right? The ecosystem, it's not the OS itself. You remember the Android case. It's you want to have access to, I mean, all the functionalities that may come with it. So you need an app store. We know that, like the OS itself is a bit of an empty shell. So, but it was not possible. You had to take maps and everything. So it has the ability to there was a risk of foreclosure of rival map providers, including TomTom. So I advised TomTom on the case, and voice assistant, rival voice assistants as well. So that's one but. The second is a tie, but this time within the Google APIs. So search, you have several APIs, so search APIs and then maps. And essentially, the condition that the restriction that Google was imposing is if you want to have access to search, you have to use it in combination of Google Maps. So you can't use it in combination with some third-party maps. And that is part of the remedies. So anyway, the German authority looked at sort of all sorts of evidence and decided to intervene. What I'm sort of curious to see the impact of this on the market, because arguably this happened before, and that's why we have regulation. So that's why I found it quite interesting. It happened before the market has tipped too much. So and then it means you don't need to show dominance, because in this like fast-moving market, maybe establishing dominance would have been more difficult because you don't have a clear-cut case, as but then it's too late. So I think it's quite interesting because it can be complementary when you think about it. It's like abuse of dominant position, but you need to be dominant already. Or even the DMA, you need to be a gatekeeper, but if you're a gatekeeper, you're already dominant. So I think the process, what you have in the US, the process of monopolizing does not necessarily exist in the same way in Europe. But that is a good example of what can be done with these new sort of regulations. So yeah, I'm curious to do some kind of ex post assessments, and hopefully it will move the dial. And just one thing, the remedy is not just Germany. The remedies are to apply in Europe. That's quite important for many reasons. But if you look at the press release of the German authority, you'll see why they put that quite prominently, that it will have European-wide implications.
And also maybe on another case, we hear how important the press publishing industry becomes in these chaotic days and in these technologically challenging days as well. We have some jurisdictions who've been trying to give some greater visibility or liberating it from being so subsumed to big tech undertakings. And we also hear something similar, or some similar attempts in the European context as well, EU and some member states, and obviously big tech industry or some players try to respond on it. Can you highlight the latest developments as well?
So are you talking about, for example, the remuneration of news publishers on say Google, on potentially other platforms? Yeah, so it may be complementary to the AdTech case because it touches as well on you know on the sort of the financial situation of news publishers. So just to explain what the case is about, there are new laws, in particular in Europe, so neighboring rights, saying, well, you need to have permission from news publishers to reuse the content on Google search, but it's literally everywhere, right? So if news content is displayed on the search results page, you need to receive permission from news publishers, and the idea was there is an imbalance of bargaining power between Google and news publishers. This is protected content, and Google and Meta that should pay for it. Started in Australia at the time, and we were involved as well. And I think the intervention there is interesting because it is intervening, but rather than saying, I want Google and Meta to pay some kind of price to news publishers, it was a sort of hybrid intervention and say, I'm going to set the rules. I'm going to try and design a regulatory framework so that the imbalance of bargaining power is resolved to some extent. But I don't want to intervene. I don't want to do price regulation, kind of, right? I just want to set the rules and then say, this is how you should negotiate. This is what you should take into account. And then the price, and then you have bilateral negotiations between news publishers and Google. So yeah, I think, I mean, that's kind of the law. And that was the intention of the legislator to rebalance a bit this bargaining power. And once you have that, and you say, okay, in a more balanced situation, the economic question is, what is the value to Google of news content? What is the value to publishers of news content? And then what would be, given that, think of like typical what we would do in Nash bargaining, what would be the price that would come out of it? And based on many studies, I mean, typically on behalf of publishers, right? So of course, that there are, but you need to look at sort of the evidence. But when you do this, you need a significant transfer from, say, Google to news publishers, just because the value to Google of news as a whole, once you rebalance bargaining power, you need to think of news as a whole. That's the point. Is higher to Google. And what is not necessarily intuitive initially is that the value to publishers, news publishers, of having their content to Google is potentially less than what you would think initially, because if you remove all news content, you will have some redirection effects. People won't stop reading the news if they are not on Google. That's the point. It has some value, some discovery value, but they won't stop altogether. So you will find other ways. People will learn to consume the news by some other means. So anyway, these are the economics, and what you might have seen, because I was a bit surprised by the study that was published by Google. Google removed news content to test, okay, what is the value to us? If I remove news content, what happens? So there is some kind of A/B test. I'll skip all the nuances, but essentially a bit shocked by the results, because they say that once news content is removed entirely on 1%, they did that in a couple of countries in Europe, not in France, because they were not allowed to do that, it had no impact on Google. And I think that's a bit shocking in a way, because what does it tell you? That you're degrading the quality of your sales results page. People are looking for news. They don't get news. They get something else. They click anyway, and Google makes money anyway. That I don't know. It's question mark as to what the study actually shows you. If not that, there is some kind of concerning. It's like the typical, not a snip, but the equivalent with the quality. There is a quality decrease and nothing changes. No impact on revenue. So anyway, I don't know. Maybe there is something else, and it's going to be debated. But yeah, that's I think interesting.
Many thanks, Mikaël. The DMA, 2 years pretty much, and also maybe its UK equivalent, which is still in semi-hibernated mode, so to say. What are your reflections on both legislative regimes?
So, I mean, the DMA is Well, I think that because when I hear like critiques of the DMA, is we need to enforce it. It's the law. So I think that now we are past the question of whether it should happen. It needs to happen. So I think the first thing is let's enforce it. That's what needs to happen in my view. And of course, we have two recent decisions. So Meta and Apple. So it's happening. The question mark. The question is, what is effective compliance? So you have to have compliance. What is effective compliance? And of course, maybe I'll say that, but I do believe that there is a role for economists there to look at effective compliance. An example of that in the Meta press, the decision on Meta, I noticed that the Commission said, we are interested in the actual impact of your new model, like pay, model. I want to see the impact. So it's not, it looks like, as we've been saying, many people have been saying, it's not a tick boxing exercise. It's actually, you need to have some effect. So show me that it moved the dial, which I think is interesting because, if you're on the other side, you're like, okay, but if it is compliant, it is compliant. If it has no impact, it could be that, well, it has no impact because actually people still want to use my services as they were before, right? So I think like forcing some effects on the other hand is also might also be going a bit too far. But anyway, it's on a case by case basis that you need to look at these things. Now, in terms of impact, so it's 2 years, but it's still very early on, and I would say that it makes sense that it's going to take some time for everything to be in place. And also, if you have non-compliance decisions, it means that we can't look at effects. But essentially, what I would say is we need effective compliance and then do some kind of ex post assessment. I mean, the nice thing is we'll have intervention on many markets. We need to look at what is going on. This is so rather than sort of necessarily predict, just have a sort of evidence-based approach. And if it needs to be revised, then we can think about it later on. I know that Fiona Scott-Morton particularly is actively working on sort of empirical, with some others looking at the impact of the DMA so far. There is a workshop in Brussels organized pretty soon, or depending on when this video is published, maybe it will have happened. But yeah, so and that makes sense. That makes sense to, of course, not be dogmatic and look at. I think it's a great opportunity for economists because you have these sort of natural experiments in a sense, and so let's take a look and see if it's working. The MCC is a bit different. It may be a bit slower. Yeah, on speed, I think that's an interesting one. On speed, so as you know, the DMA rules are based on past cases where we have built knowledge. So I think it's not like we decided to intervene without any evidence. I think the evidence is there. And then it's more like we are already in the remedy phase. We know there is a problem. It's like the remedy implementation kind of continuing. And to me, that makes sense, and we should be quick. Now, for new technologies, we have to be careful because I get it that we don't want to repeat the mistakes of the past, kind of. There is this idea like mistakes of Web 2.0. But I think the failure was not so much in failing to identify the problems, it was failing maybe to intervene once the problems had been identified. So what I mean by that is, if we can't see, I'm thinking about AI, for example. AI raises many questions and many issues, but if it's more speculations about what may happen, I find it more risky to intervene from a competition perspective, like leaving aside all sort of, there are many reasons to intervene for other reasons, but from a competition perspective, it looks like as if there is a lot of competition at the minute, and it's more concerns. So I would be a bit more concerned if we were just, it's speculative concerns, potential concerns to intervene now might be too early, and we can just wait. And unless you can't, course correct, but I don't see why, then it makes sense to wait and see. And on whether you can course correct, then you need to look at the market features. And I think in AI, it's not, again, a foregone conclusion that you have exactly the same features as in the digital space, like in Web 2.0, because the network effects are less clear. I think it's at the minute, we don't exactly know if you have, whether basically all the features of the market mean that the market is prone to tipping. It's not, you could have like a competition with a couple of maybe large players, but not you won't end up in the same situation as such. So I think it requires some a more cautious approach. And if I were to give a less good example, so because is maybe the Data Act. So potentially because I looked at this, but the Data Act, I think on some aspects was a bit rushed when it touches on competition regulation in cloud. And I think a good evidence of that is the amount it is taking to the CMA to look into cloud, to think about these issues carefully. And the Data Act was just imposing some kind of functional equivalence, and I think it's there. So rather than even say, oh, was it a good or not, I was a bit surprised that it was lacking some economic evidence to decide to intervene. And second, okay, now it's happening, fine, but let's look at its impact, because many people are working on it, and from what I can see, it's not having a very either no effect, but still very costly from a regulatory perspective, or not necessarily the effects we want to see, especially with competitiveness and all that. So
interesting. Students, they are facing so many opportunities, but also perplexities. So much is going on simultaneously, moving them their attention in the opposite direction. So they need good steering advice.
So on those that are undecided or decided. So I mean, if for those that are undecided, my piece of advice would be just join. I think it's like an amazing field. Well, my friends make fun of me sometimes saying I'm too passionate about my job, but I truly believe it is extremely interesting. It can have a, it's interesting, rewarding, can have a real impact on the economy, on people's lives. So, okay, that's one for those that are decided already. It is, you can do many different things. So maybe think of what is your main interest, because you see that you can play many different roles within this sort of antitrust community. So find this, but at the same time talk to other people, like other fields. I think there is a lot, especially nowadays, we realize, of course, that we like competition, but there are other things. So it's super important to keep this open mind, and then talk to other regulators. Think of, just listen to them and understand what their objective function is, because competition is of course not everything, and in particular, just a reflection, but it's innovation and this discussion. I think there is a question mark about whether competition on its own can set the right path to innovation. I think it can get more innovation, but not necessarily, so it's like the engine in the airplane, but you need a pilot as well. And the pilot, is it just competition, or is competition just an instrument? And then you need other things. And I think maybe you need other things, of course. So anyway, keep this open mind and realize that, you don't want to be just a purist. And then speak to people that disagree with you. I think it's quite, that makes it even more interesting. Either you're right and great for you, but if you're keep in mind, it's not the point to be right. The point is to learn something in the process, and get a better outcome ultimately. So that, I think, keep sort of humility and curiosity. That's what I would do.
Absolutely. Mikaël Hervé, thank you very much for this very informative and eye-opening in many respects conversation. Thank you very much.
Thank you so much for inviting me, Alessa.